Be honest, 501 to 749. The final will be 750 to 1,000, which is the end of the book. Or 1001.
I don't think I've ever read an entire book for a class, so I'm pretty impressed with that.
Much less a
Haven't
1,000.
finished it yet.
Pretty impressed.
Much less a 1,000-page book.
Like the printers.
All right, now for those of you who weren't in here last semester, this midterm is the only time you're going to see the material on pages 501 to 749. It's not going to be on the final. So it's one test. The reason I break it down like that for you is because really half a book, an entire semester's worth of stuff in one exam, is pretty rough. You need to get indoctrinated into law school, and doing it by quarters is easier than doing it an entire semester at a time. We're expanding the brain to hold more stuff. All right, let's start off with 501, form contracts. Standard form and adhesion contracts. On your outline, I list the several advantages that come straight out of that material. And the characteristics of an adhesion contract: disproportionately strong economic power that you can dictate your terms, no opportunity to bargain over the terms at all. It's a take it or leave it proposition. Now, how many of you go shopping at retail stores? Do you ever ask them about reducing the price? Except for except for something that's damaged. Do you ever look at the price tag, you go up to the cashier and say, I don't want to buy it for this, I want to buy it for something less? All right, if you're ever on vacation, like in Mexico, have you ever said, I don't want to spend this much on it?
And they bring it right on down.
All right, so why don't you do that for big corporate America instead of just the poor Mexican nationals trying to make money? You think you might have a better bargaining position?
Yes.
Because you can go the next stall over and buy the same thing, right? Same thing's true with Walmart and Target. You can do the same thing.
Yeah, but they don't care because they don't go directly.
So if I were to go into Help and say, hey, this dress, I know it's already on sale, but can you give me $50 instead of $70?
I'll say open a credit card and we can
That would
Well,
give you
that's
10% off your first
point.
open a credit card.
My wife deals with that all the time. She manages Kay Jewelers, and every day somebody, well, I don't want to pay $5,000 for this $7,000 ring. How about I pay $4,000 for it?
Actually, I did the same thing over at Michael's not too long ago. We had a piece of art frame. We already had a 70% off coupon, and they said, we've got a lot of rush orders here at Christmas time. Do you mind if it takes longer? I said, not if you knock some off the price. And they knocked some off the price, even with 70% off already. All right, before I go any further, I've got to tell y'all, I told you that I had a case coming up in a small town that there was a traffic ticket and I was going to just beat the crap out of the prosecutor on it. I got to tell you what happened. My client got a ticket for having a improper tag. Have y'all ever heard of an improper tag?
I see it on that.
Do you know what that is?
No.
The officer told the prosecutor the reason he gave my client the ticket was because the little sticker with the date on it didn't have the current year on it. Client had the receipt for where they paid for it online to Jefferson County Revenue Department, had the receipt 2 months ago, and they still hadn't gotten him the sticker, so they gave him a ticket for an improper tag. So we set it for trial. As it turns out, one of the first things you need to learn about the law is always go look up the law.
Wow.
Always. So I went and looked up the statute for an improper tag. Do you think an improper tag includes not having the current year sticker on it? It does not. The statute for an improper tag is that you have a tag for a different classification of vehicle on your car. So if you've got an 18-wheeler semi tag on your passenger vehicle, that would be an improper tag. Or if you had a trailer tag on your motorcycle, that would be an improper tag. See where I'm going with this?
Yeah.
All we had was the right classification, but just an expired sticker. But proof that it had been renewed in time, just didn't have the sticker on it. So when you go to trial on this, and you tend to over-prepare for trial, I have the statute that says, here's what an improper tag is. And then it goes further in the statute and says, if you're found guilty of this, the punishment's provided by another statute. I got the other statute, it had been repealed. So even if client was found guilty, there was no punishment for it. Because the legislature said it can only be punished according to this statute, which they repealed. So now we're going into this courtroom ready for the battle of a lifetime. waiting to drop this brilliant legal argument onto the judge. And we get up there and the judge calls the case ready for trial. And I'm ready to sit there and make this legal argument and win just big time. And show out in front of all these other lawyers. Prosecutor gets up there and says, officer's not here, we have to dismiss the case.
Did you get paid? Did you get paid by your client for representing him?
No, it was a pro bono. And you're supposed to do pro bono too, by the way. But I told you last semester I'd tell you how that case comes out. All the brilliant legal work in the world and all the preparation, and you get there, it's like kissing your sister. It's a kiss, but it doesn't mean anything. So it's a victory, but it just kind of fell short of expectations. So if you're going to learn anything out of that, when you get a client charged with something that you don't usually handle, go and look up the darn statute. Because they may not be able to prove their case. And that is a fun victory when they put the witness on the stand and ask them these questions about an expired sticker, and they say, we rest, and you look up and smile and say, Judge, we rest too. Judge move acquittal. Here's the statute, they didn't prove a thing in here. So, over-prepare rather than under-prepare. All right, the rest of the characteristics on 501, obfuscating clauses that you can't understand what it says. Fine print, or it's used by the party that has an advantage of time and expert preparing it. That's your standard car sales contracts. They prepare those, and you either buy the car according to the terms on that contract or you don't. It's got arbitration in there. You ask them if they'll change it, and they won't. The reason they don't do that is because they paid their expert to prepare the form, and they're in a far superior bargaining position than you are. So those are your adhesion contracts. All right, O'Callahan versus Waller and Beckwith. That was the exculpatory clause used by the landlord for their own negligence. Remember what happened in that case? They lost. The landlord won because he had an exculpatory clause in his contract. So look at the caveat down there. Now most states have provided by statute that you can no longer use an exculpatory clause in a residential lease. That's where the legislature goes back and corrects the mistakes that the courts make. And it is routine. Graham versus Scissor Trail on page 508. Concert promoters dispute subject to arbitration by his own organization's arbitrators. You remember that? He was trying to, I think, recover lost money on one contract on another contract, and they had a dispute about it. And he said, okay, you got to use arbitration because it's in the contract. And oh, by the way, the arbitrator is one of my employees. Guess how that's going to turn out? The court held that that was improper. You have the judicially imposed limitations on the enforcement of adhesion contracts. if it does not fall within the reasonable expectations of the weaker or adhering party, or a principle of equity, even if the provision is consistent with reasonable expectations. It'll be denied if it's unduly oppressive or unconscionable. Either or. If it's oppressive or unconscionable. All right, agreeing to boilerplate, fine print. Remember what it said about fine print? Well, it assumes that you have read the contract, right? Remember what restatement 211 says about standardized agreements? You still can't sneak in unexpected terms into standardized agreements. They have to be consistent with what the parties would expect in that contract. The doctrine of unreasonable expectations on 512 at note 2. When insurance is sold in circumstances that discourage detailed inquiries, reasonable expectations of the buyer should be honored even though the policy terms do not support them. How many of you have ever bought travel insurance? What if it said on your travel insurance that it'll pay for medical bills, but then it turns around and says, any medical bills caused by slip and falls are not covered? Isn't that what your medical bills, your insurance is supposed to be for? Now, do they give you the opportunity to review the terms before you buy it?
Yes.
No.
Yeah. You're supposed to, if you do it online. Yeah.
Some of them do, some of them don't.
Yeah, the problem is you need 2 magnifying glasses to read them.
And you got to scroll all the way down the bottom.
Yeah.
There's a scrolling in here as well. All right, we talked about design features to entice you to sign a contract, such as small down payments, teaser rates, and other salient terms. 90 days, same as cash, stuff like that. What do they expect you to do on those?
Not paying.
They expect you to default and not make your payments so that your 1 year, same as cash, has a 27.99% interest rate.
Backdated.
Uh,
Backdated.
all the way back to the date of the original sale. So you got to read that fine print for those. All right, duty to read and duty to disclose terms on 514. I put a couple quotes in there for you that are good. Statements of law, the absence of fraud. One who signs a written agreement is bound by its terms whether he read it and understood it or not, or whether he could read or not. And a person who cannot read has a duty to find someone to read the contract to him. Now, y'all don't have that problem, but you will have clients that don't read. I can tell you in doing criminal representation for 20 some odd years, when you take this explanation of rights form that they're going to sign before they enter a guilty plea, and you say, here are your constitutional rights, read it and sign it. They'll just sign it. They don't read it. It's your duty to make sure that they understand it as their lawyer. They don't have an independent duty to find someone to read it to them. It's your duty already to explain their rights to them. So that's kind of the exception to this rule, is if it's already your duty to. Conspicuous information. The UCC defines conspicuous. They also have 2-316 in here about what it takes to be conspicuous as far as excluding or modifying warranties. Remember that? Got to be a different typeset for print in order to be conspicuous. Is it enough that you just put it in bold? Unless the whole document's in bold, right? Is it enough that you capitalize the entire phrase?
Unless the whole document.
Yeah, unless the entire document's capitalized, right? You got to make sure it stands out as being different. Truth in Lending Act, they point out, requires disclosure of the annual percentage rate. They also make the difference between a prominent entity and an average Joe. If somebody is sophisticated and knows to hire a lawyer, or they have legal training already, then they're held to a different standard than somebody who is average Joe. Just in case y'all didn't know this, you know what the average education is for a juror?
7 years.
7th grade.
7th grade.
Yes.
Is that just in Alabama?
No. Not just Alabama. 7th grade education.
So,
And that was a study that they printed up in some journal. And it was a nationwide study. .com disclosure guideline, they did. That's also on 516, where it's got to be clear and conspicuous. There's scrolling. The case on scrolling is that there was a forum selection clause, but you had to scroll all the way down the bottom to see it. Well, you can be held to be required to scroll all the way down, even though there's a couple cases to the contrary. All right, sources of policing: courts, legislatures, and agencies. Judicial, they create doctrines such as unconscionability, and they interpret contract terms. You know how courts interpret things, right? The way they want to.
no.
Yeah, it depends, right? If a court is doing equity, that's exactly what they do. Is they do what they want to. It's going to come to an outcome that they want in the case. If they strictly follow the law, then plain meaning of the words. What interpretation is there to that? And there's none. So judicially created is where the courts can interpret, even if the interpretation is inconsistent with the language. Again, they use reasonable expectations of the parties to get to that, and other reasons. All right, 3 types of protective legislation, also from that same area. Concerns about fairness of particular terms or the exchange as a whole. Seeks to control the exchange. One example of that is the Truth in Lending Act, where it says you have to actually disclose what the annual percentage rate is. That's regulating the transaction by saying you can't do one legally unless you disclose the annual percentage rate clearly and conspicuously so that the parties understand that. Facilitate various disclosure requirements for well-informed shopping by consumers. Another example, that example again is annual percentage rate. You know what the rate is for this one vendor, you can go to another and see if it's different. Credit card companies are like that. What are some of the things you look for in differences in credit card companies?
What rate?
Number 1, interest rate, right? Annual fees. You know, Disney's got an annual fee for their Disney card. A lot of banks don't have annual fees. So you get to shop around based on those types of terms, but they have to let you know what those are. Number 3, they focus on the remedies, believing that consumers suffer systematic handicaps in effective enforcement of their rights. A good example about focusing on remedies is the Federal Trade Commission, where a business does deceptive trade practices. By the way, that brings up another attorney advertisement. How many of y'all have seen the Morgan & Morgan commercials on TV? Have y'all seen the one where they say, oh, don't hire that lawyer that automatically settles all his cases. He's an idiot. Come to our firm. When you get to ethics, you're going to find out there's this rule that says you have a duty to say no representation is made that the quality of legal services provided are greater than the legal services provided by other attorneys. Does that commercial just not fly in the face of that rule?
Yeah.
We're better.
Well, if he didn't say anybody's name specifically.
All right, administrative agencies such as the Federal Trade Commission. Doe versus Great Expectations. Remember the dating case? You can sign up, but we're not going to try to send you any notices as to who might be compatible. That violated a New York state law, limiting how much dating agencies could charge. Remember, that case focused on whether or not they get anything in excess that they charged, but then they went one further and said, we even want back the original money that they could have charged. And the court gave it to them. I saw a hand go up.
Number 17, can we do that from the same number 17? The administrative agencies, the one before that. Could you explain that to me?
Which one?
The one before this example, the administrative agencies,
About handicaps and the effective.
the quasi-jurisdictional remedies,
Quasi-judicial remedy.
Federal Trade Commission.
Oh,
Could you give me some?
because they have hearing officers.
Okay.
They set up the Trade Commission to have hearing officers. Another agency set up that protects rights is the Equal Employment Opportunity Commission, EEOC. If you've suffered discrimination at the hand of an employer, you complain to the EEOC and they can actually have administrative hearings and they have lawyers to prosecute that for you if they choose to select your case for prosecution. So it is also quasi-judicial in that they give them fines and penalties, but it's not in the court system itself, even though they can go to the courts.
If they're able to give them fines and stuff, are they also able to settle, like, for the person or just for the?
Of course, they consult the person to settle it. There's another one too, the Consumer Protection Agency, where they have all these recalls. You saw where Volkswagen was falsifying their emissions records, right? If it's hooked up to a machine, then it automatically gives them a report that it's a passing number rather than giving the true number. Well, they fined them as well, and that was outside of court, so it's quasi-judicial.
Do they take a cut of the EEOC? Like if you get a settlement, do they take attorney's fees from that settlement?
Not to use their lawyers that I'm aware of,
That's what I always.
but if you hire your own lawyer, they do. All right, unconscionability, section 3 on page 522. UCC 2-302 tells you what's an unconscionable contract. That code section is cited in your book. It's actually in your other book. You need to read it. It's for the prevention of oppression and unfair surprise. And it's too hard a bargain to entitle the plaintiff to relief in a court of conscience. So that's kind of the test that they use, even though they sign it. It's too hard a bargain to entitle plaintiff to relief. All right, unconscionable contract terms in Restatement 208. And then there's a discussion. Two types of unconscionability, two views on it. The first view distinguishes between procedural and substantive unconscionability. Procedural in how the contract's made, substantively about the outcome itself, whether or not it's unconscionable. So you can attack unconscionability two ways: the process or the result. The other is two reasons for not enforcing contracts. Hold on. Proof of some defect in the process of contract formation, duress, fraud, or undue influence. That would go to procedural unconscionability. And then number two, there must be within some narrow limits some incompetence of the party against whom the agreement is sought to be enforced. Well, one example of that is if you include an arbitration agreement in your contract and you tell the party who cannot read that it's not in there, and they don't read it to know that it's not in there, and they sign off on it anyway, can you use the fact that they're unable to read and they actually asked for a disclosure of what's in there? That kind of borders on fraud too, right? Okay, what was your question? No, either one. It's either one. And if you can prove both, it's a slam dunk, right? All right, Williams versus Walker Thomas. This is the furniture purchase contract that contained cross-collateralization or dragnet clause, saying that if you default on this purchase, we can take anything you've ever bought from us before. Remember that case? Is that unconscionable? to take away something that you previously bought, that you paid for in full? And the court agreed with you. Terms that you have to look at are shopping radius on page 530. How far out do you have to go in order to get that product without that term? Distributive justice and incapacity. All right, price unconscionability. This is the $300 freezer that they sold for $900 that they had only paid $600 and something on. The court said that's plenty. You don't have to pay any more. The term that the court used for that is it remitted the balance due on that account. And the language they used is may be apparent from the intrinsic nature and subject of the bargain itself, as such that no man in his senses and not under delusion would make. That's a great quote.
Yeah.
You've got to be out of your mind, is basically what it's saying. All right, fraud and high-pressure home sales. How many of you have heard of the Rainbow vacuum cleaner? How many of you have bought a Rainbow vacuum cleaner? All right, the other thing you need to know about in-home sales is you've got 3 days to rescind your decision on that. That's federal law because they recognize that in-home sales are usually high pressure. You don't have a place to run and hide if they're already in your home. Uniform Commercial Consumer Credit Code also has terms about price unconscionability. And as an interesting fact, maximum credit rate to military personnel is 36%. That's federal law. That's a great piece of trivia.
Is that supposed to be good? I mean, like, what's the...
Huh?
So is that supposed to be good? Like, well, I mean, why?
Is that only for like
Well, yeah, because they were,
Well, it's-
we have paid and for going.
Yeah, that's what military is
Yeah, that's what it
any longer title clause.
Oh, at least 4 times. All right, unconscionability and franchises. Now, if you want to buy a franchise, are you really at liberty to negotiate with the franchisee if you really want to sell that brand? No, you're going to sell it exactly how they tell you to sell it, aren't you? It recognizes the superior bargaining position in it. So they've created federal minimum standards for disclosure applicable to all franchise and business opportunity offerings. That's the code section that creates those standards. Unconscionability and arbitration clauses. For employment contracts, they uphold arbitration clauses. Mandatory arbitration agreements and employment contracts are generally enforceable under the FAA, save for upon such grounds as exist at law or in equity for the revocation of any contract. Now, why can you get out of an arbitration contract? For any reason you could get out of a contract, right? Fraud, duress, unconscionability, all the factors we've covered on unconscionability, whether or not it's procedural or substantive. If you don't recognize it yet, I'm telling you, this is how to get out of arbitration. That's going to become important to you when you get out and start practicing. Scott versus Singular Wireless. They had a class action arbitration over long distance and roaming charges. And the state of Washington said, our court rules allow for class actions, which cannot be waived by contract because there's no sense in suing over $30. An idiot would sue for $30. However, when a whole bunch of idiots that don't sue over $30 come together, then it can be a lot of money. So we're going to allow class actions. And then AT&T Mobility versus Concepcion, U.S. Supreme Court case, came in and said that interferes with the Federal Arbitration Act. So while Scott versus Singular Wireless is a case that holds it, the U.S. Supreme Court has turned around and said, too bad. If you agree to arbitration, you're going to have arbitration. Save for except any reason that you can get out of a contract, which would be unconscionability, fraud, duress, undue influence, all those reasons. All right, performing in good faith. Oh, the note. Some courts trying to get out of the AT&T holding allow a waiver as a defense. Now that's still highly in flux. It's changing a whole lot these days, but there is a tendency to use waiver as a defense to the class action arbitration. Now, good faith. Restatement 205 and UCC 1-304 creates good faith regardless of whether or not it's a good or not a good.
What do you mean waiver as a defense, not following?
Well, as an example, if I file a lawsuit, a class action lawsuit against a company, and the company comes in and files an answer, and then they start asking for discovery, and a year goes down the road and they finally say, oh, this needs to be arbitrated. So they file a motion to compel arbitration. Well, what happened during that first whole year? They were participating in litigation, right? The courts have held that that's a waiver of their right to enforce arbitration when they actively participate in the litigation. But that's a procedural thing. For the substance, you know that waiver may be a defense to arbitration, but it usually happens in the context of procedure. Yes?
I was out the week we talked about arbitration. Can a judge, I know a judge can recommend arbitration, can they compel arbitration?
It depends.
Okay.
Is it Alabama Arbitration Act or the Federal Arbitration Act?
We're in Alabama, we'll go with this backward state.
In Alabama, once an action has arisen, a dispute has arisen, and you agree to arbitration, then the judge can compel that. If you agree to arbitration before a dispute arises, under the Alabama Arbitration Act, it cannot be compelled.
Okay.
However, the Federal Arbitration Act, you always agree to arbitrate before the dispute arises. And as long as that contract affects interstate commerce and you've agreed to arbitration, then the courts will always enforce arbitration unless they waive it. That's the most frequent cases I've seen is they go ahead and participate in the litigation and then decide they want to arbitrate. So that's a big, it depends. For this class, we're only studying the Federal Arbitration Act, so you agree to arbitration, you're going to be stuck to it. Unless you can get out of it for a contract reason. By the way, waiver is a contract defense too, right? If you waive your rights, one of the cases in here, still in this material, is it a waiver for you not to insist that your client pay their bill on time? No. It's called leniency, right? It's the rule of leniency. We're getting to that. Just keep that thought in the back of your head. All right, performing in good faith. After the restatement in the UCC, which defines what good faith is, we have Dalton challenging his SAT score. Remember what happened in that case? He was trying to force SAT to give him his higher score, and it got reversed. The only thing that was guaranteed in their contract is that the EDT, ETS, would actually exercise discretion in looking as to whether or not to certify his score. But they had a duty to exercise their discretion in good faith. So it got reversed, ordering ETS to exercise their discretion in whether or not they're going to certify his test score, rather than forcing them to certify his test score. So the good faith on this case was they were requiring ETS to use good faith in their determination as to whether or not they'd certify the score. That's a complicated holding, but I think it's actually the correct thing, rather than telling them what they have to do. The contract was, we have this system to contest it, and we'll use this system. They refused to even entertain it, which is why the suit was brought. All right, Hilton Hotels versus Butch Lewis. This was the Leon Spinks title fight, that they were going to unify the titles. And Butch Lewis Productions decided, hey, we can get more money if we strip him of his title, and we can have another one of these events and charge even more money. And that caused a lot of people not to want to go to the Hilton in Las Vegas, because it wasn't truly going to unify the titles. And Hilton brought suit and found out, yes, they had to have good faith in performing, and you can't strip away a title when it was the reasonable expectations of the parties making the contract that it would be a unifying title fight. UCC 1-304, again, obligation of good faith. It came up twice in that section, so I think that's probably important. The content of the obligation of good faith. 1-201 of the UCC says good faith as honesty in fact and the observance of reasonable commercial standards of fair dealing. That was important enough to type that one out. Then there was this commentary on what is good faith. The first one by Robert Summers says good faith is what it isn't. He said it's a whole lot easier to give you examples of things that aren't good faith than it is to come up with an overbroad definition of what is good faith. So what does that tell you? It depends, right? If it doesn't pass the smell test in court, it's probably not good faith. But they're not going to give you a broad general definition of what is good faith. The Permanent Editorial Board says good faith merely directs attention to the party's reasonable expectations. It's not an independent source from which rights and duties evolve. So is there a duty of good faith in a contract? Not a separate one. You expect them to exercise good duties in performance of what they've agreed to perform, but your expectation is, what did they agree to perform? It's not that they have good faith in doing it. That's what it means. It's not a separate enforceable right. It deals with what your expectations are instead. De La Concha of Hartford versus Aetna. This is the lease of mall space to sell tobacco, where the tobacco sales plummeted and the rent amount was disputed. This is the mall that didn't want to continue to pay for advertising because it was already losing a whole lot of money. Remember that case? So was it bad faith not to try to get people to come to the mall? No, because they were already losing money, right? Market Street Associates versus Fry. They refused to allow JCPenney to refinance and buy back a store based on paragraph 34 that both parties knew was in the contract or should have known was in the contract, even though he never specifically said, we want to exercise our option under paragraph 34. He never said that, but the parties should have known about it. The fun quote out of there is that taking advantage is not exploitation of superior knowledge or unbargained for expense. It is sharp dealing. So if you've got a contract and you know the terms of that contract better than your opposing party, that's not your fault that you know it better. One thing is, you might actually read it. I'll give you an example of one of these. I had a client, had a son that rented a trailer from his girlfriend's parents. Actually had a signed lease. I'm renting this trailer from his girlfriend's parents, and guess what happened? Things went bad with the girlfriend, right? So the girlfriend, now former girlfriend's parents, sued him for breach of the lease.
On what grounds?
On grounds that he stopped paying. So, can they recover money from him for breach of the lease for stopping payment of rent?
Unless it says.
All right, how many of you say yes?
You don't have to pay it.
How many of you say no?
It depends on what it said at least.
He promised to pay rent and he left.
Did he have consideration?
That all he promised? Was that it?
No, the other promise was they promised to deliver to him the property for him to live in, and he promised to pay the rent. There's the mutual promises.
Okay.
So when he moved out and didn't pay the rent, did he owe them the rent?
Yes.
No, was there a written contract?
There was a written contract
Yes, he did.
Oh, written with consideration.
with consideration.
So, yeah.
Unless it said, like, if things go bad in the relationship.
Here's how I got him out of it. The lease said that they would deliver to him exclusive possession. Girlfriend was already living there. They never performed. So they breached first.
Okay, question.
Yes.
So, had they not broken up, and evidently they were going to be living together,
They were living together.
so I'm still trying to understand that. So you're saying based on the fact that she was there, he did not have exclusivity?
No. The parents promised to deliver to him exclusive possession for him to live there.
Right.
They never kicked the daughter out for him to have exclusive
But
possession.
they never were.
They were never going to.
They should have put those words in the
They shouldn't have put in the contract that he would be delivered exclusive possession to live there. And because they did not do what they were supposed to under the contract, he didn't owe them any rent.
It's all over that word exclusive.
So that's
All over
why-
the word exclusive. So, does it matter what the contract says?
Yes.
They drafted the contract, right? But who knew the contract better?
His lawyer.
Well, he did.
His lawyer.
So he was able to get out of it because of language that they put in it. Now, is it anything that they didn't expect? They wrote the thing, right?
Well, they didn't
How
know
did
that,
they write
probably.
it? Did they find something
Probably got it
online?
approved.
They probably found something online.
Okay, that's what I'm...
If I ever see you in court, I'm running the other way. Like, I'm not
You
coming
don't
in.
need to. All right, so the parties knew or should have known and understood the terms. Taking advantage is not exploitation of superior knowledge. It's called sharp dealing. And where you can point out that they breached first, yeah, they'll never get equity in that court, are they? All right, opportunism. Two types of opportunism, or two circumstances. There is an effort to wring some advantage from the fact that the party who performs first has lost money, and that if they don't agree to your additional terms, they're going to lose that money that they invested. That is called opportunism. And the second one is take advantage of one's contracting partner in a way that was not contemplated by the contract. I.e., there's unexpected expenses that come up, and you tell them that they have to incur it rather than you. But then neither of you anticipated those expenses when you made the contract. Your insistence that they pay for it rather than coming up with an agreement on how to handle it is the other type of opportunism. Bloor versus Falstaff Brewing, they used their best efforts clause to sell beer. And they got really mad because they sold other beer that made them a bigger profit than the beer that they promised to use their best efforts on. Remember what the court did? Yeah, they were entitled to lost profits, right? As long as there was a reasonable estimate of the royalties. Lucas versus Ham. I just put that one in because that's the one that says a lawyer who does not understand the rule against perpetuities is a lawyer exercising the ordinary skill and capacity ordinarily exercised by other lawyers, because most other lawyers don't understand it either. So is it malpractice not to understand it? Apparently not in California. Then on 573, note 3, there's the single firm concept about best efforts. instead of using vertical integration in a single firm, they argue that they can most sensibly be construed by requiring a level of effort to maximize joint net product flowing.
Could you explain that?
How can I maximize the sale of beer? If I'm the distributor to use my best efforts to sell your beer, how can I use my efforts to get the most of your beer sold?
Spend money.
I mean, there's a whole lot of ways. Can you go out and give free samples?
Well, not to people under 21.
Not to people under 21. I don't think you can give it in Alabama at all, can you?
Probably not.
Not free alcohol? Can't what?
You can't advertise it either.
Well, it's fine.
Y'all have seen these things that they have, this beer garden thing? A beer celebration that they have here in Birmingham? You gotta pay to get in, right? So they're not giving the beer away.
We just went to this bourbon thing, and they gave us a bunch of pennies, like for each tasting that we were supposed to have, and then turn in the ticket and the penny so that they could like cover their butts.
That's a smart.
They have to have a separate vendor come in and do them. The owner of the business that sells the wine cannot do it. So they make their break the law.
Maybe they hired somebody that actually had a beer and wine license because they didn't have one. They have the ability to produce it but not sell it.
They don't, it's not a bar or anything. Only on those nights when they allow it to.
All right, on 573 at note 4, they talk about exclusivity as far as soft drink vendors. And the trick on that is that the trade practice and usage for soft drinks is that a vendor only sells one soft drink. Coca-Cola doesn't sell Coke and Pepsi. Now, Coca-Cola might put Coke and 7-Up in a machine, but usually it's the business trade practice is to have one product. And then they did, what the other one was, a publisher. Publishing books, even their best efforts doesn't keep them from being able to sell books on the same subject. They just have to market yours to whoever wants to buy it. All right, public policy on 574. Two types of public policies, one that violates criminal laws. They called those explicitly illegal contracts. Hire somebody to violate a criminal law. And the two exceptions to that are usury and gambling. And then the second one is where courts detect or derive a policy from legislation related to the subject of the agreement when the statutes are silent on enforceability. The example they gave you is Equine Activities. If you're going to run a stable for people to ride horses, you are exempt from liability if they get thrown from the horse. That's just a statute that they passed that says they have that exemption from liability. That's a public policy. Another one that they say you cannot do is for the New Orleans Saints pay for performance bounty program, $1,500 to knock out an opposing player, $1,000 to have him carted off. And they doubled and tripled it for certain players and during playoffs. That's straight out of your book. They held those are illegal too. And then the NFL passed a rule that says you can't have any bonuses outside your NFL contract to keep that bounty program from happening again.
So what if the bounty program is in the contract?
You can't, because it's illegal.
It would be an illegal contract.
But it's a final fee. You can't pay them extra for illegal?
No,
Not certain players going after.
Let me ask you this. What is the reasonable expectation of an NFL player when they step out on the field?
They're going to get hit.
Yes, but it's during a normal tackle, right? Not an assault.
Fair enough.
we went over that case, and what such a player
It's gonna be
scope
within
of
the
the game.
framework of the rules.
Did y'all see the tackle they did, I guess it was a year or two ago, where one of the college players actually picked up a player and body slammed him down?
Oh, yeah.
You remember that?
It wasn't Alabama.
You don't expect those either. They get a penalty for that. Unnecessary roughness
In
or...
hockey, they expected to fight fist to fist, but they did criminally charge a hockey player for using a stick. You can, I mean,
That's good to know.
What was that?
Hockey players, they expect fist fights, but not using the stick on them.
Because he was out, I mean, he got seriously.
yeah, because he got his butt whooped in the fight, so when he picked up his hockey stick and then clocked the guy upside the head with it.
So
That guy got
how is
serious.
getting one by hockey not an assault?
It's expected.
It is-
In hockey,
It's part of the game.
You expect assault
It's part of the
in hockey,
game.
but assault is bad in football.
Yes.
Yeah.
If you, give you an example, about
It's the reasonable expectations of the parties.
About 15 years ago, we were watching this game when Florida State were playing. A Florida player, after a tackle, twisted
God, how
the
many people
ankle.
violated their probation in that game?
Most of Florida State's team, but they twisted the ankle of the Florida State player. After the play was over, he tried to sue him. Yeah.
And that was the Florida State player that twisted the.
All right, let's get back on track.
That's a disaster.
Bovard versus American Horse Enterprises, where they were selling their drugstore, literally, where they had drug paraphernalia and jewelry on sale. They breached the contract and they were trying to enforce the sale. Court held that because this is drug paraphernalia and that's illegal, the sale is therefore illegal and therefore has no remedy. Out of that case, actually, there's a quote that says, "Public policy is an unruly horse." That's a great quote that they love to use on public policy opinions on contracts. And then restatement 197 about restitution in general, unavailable. Then they talk about clean hands. XLO Concrete versus Rivergate Corporation, where they bribed the concrete consortium, I guess, to award them the contract. They got the contract, and then they didn't want to pay the final installment for the concrete that was delivered, and their ground for it was, hey, it's an illegal contract because we had to get a bribe in order to get the contract. Remember that case? Did they have to make that final payment for the concrete? Yes, because it was separate from the contract itself.
He said something about that New York is up to the New York Attorney General or something like that
To prosecute, yes.
Extortion, business, unsafe business practices.
All right, inducing official action, foreign and domestic. Bribery of a public official, and also foreign public officials, is unenforceable.
Okay, so illegal and unenforceable, correct?
If it's illegal, it's unenforceable.
Oh, okay.
I think there was a contract case in here I may have missed that was, they bribed a foreign official in order to get business in that country. And of course, because of the bribe, they got the contract, and then they tried to sue for whatever they were entitled to under the contract, and they did not allow them to do that either because it was a result of a bribe.
Is it bribery when sales reps like take people to lunch and things like that? Is that bribery or is that?
That's called lobbying.
Or marketing.
Marketing?
But it's the same
part of business.
concept because you know, like medical sales reps, they like take doctors on trips and or CEOs on trips, and then they bring in their product.
You've been watching The Fugitive, haven't you?
No, what is that? I need to watch it.
Harrison Ford?
I watched The Resident.
Y'all remember that movie?
What's that?
The Fugitive?
I'm looking at. Oh, that's 1993. I wasn't sure. I gotta watch that.
All right, in the fugitive, that's what they did, is they took the doctors on a trip.
It's a budgetary item.
Huh?
That's a budgetary item for a lot of companies.
So is that just lobbying?
Or marketing,
Okay.
or
Bribing?
or if it's a kickback, that's illegal. Depends on if they're getting anything besides just the gratuitous stuff. If they're actually getting money back, then that'd be a kickback. Commercial bribery, restatement 193 and 178. There was a case mentioned in here, it was in one of the notes, about where they tried to bribe a judge. Remember that? And then when they figured it out and they were prosecuted, then they brought a lawsuit to get their money back from the judge. And I think the quote out of that case was they let him to stew in his own juices. That we're not going to let you get the money back because you had unclean hands to start with by trying to bribe the judge. All right, license laws. We talked about this in class, is that if a business comes into Alabama and starts doing business without a Alabama business license, that Alabama won't actually let them sue for the breach of the contract until they become qualified to do business in Alabama. That's some of the licensing law restrictions that you have to have a license to do in order to support your ground for relief. Now, what about attorney fees? If I have a secretary that on her own decides to go ahead and start drafting wills and starts charging for wills, and somebody decides not to pay, can my secretary sue them to recover the money that they had agreed to?
Under your name?
Why not? Because drafting wills requires a license to practice law. And if your secretary does not have a license to practice law and is doing this without your knowledge or supervision, then they don't have the license necessary to do the work and they can't recover for the work that they've done. That's the other example we had covered in class. All right, judicially created public policies. Restatement 179 gives you bases of public policy against enforcement, and restraint of trade and impairment of family relations is the intro to our next section. Restraint of trade is the first one. Restraint of trade is Hopper versus All Pet Animal Clinic. They signed an agreement not to compete. This is your non-compete agreements. Now, why did the court say that it was going to be enforced? Because he learned all sorts of stuff by working at that clinic, right?
Yeah, and it didn't.
How much to charge, what types of services to provide.
Clients.
Clients. Now, is that a protectable interest for that veterinary clinic?
Right.
Yes, it is. So, how long and how far are they going to protect it? Well, they actually said that they would protect it for the type of activity and geographic limits and durational limits. So a reasonable time period, which I think they use is 3 years, a reasonable geographic region, which because it was out in the middle of nowhere included the entire city limit, and the type of activity, they limited them from practicing veterinary medicine on small animals, but they said they could actually practice on large animals. So the type of activity, geographic and durational limits will be upheld as long as they're reasonable. Attorneys on 593, note 3. Can you prohibit an attorney from practicing? No. Most professionals you can, but attorneys no. Clients are free to go with whatever attorney they want to. That actually comes out of the rules of professional conduct. They introduced this concept of a blue pencil rule. 594. And that's where a court actually interprets a document, that if one provision in there they believe is non-enforceable, then they use this imaginary blue pencil to strike that provision out and leave the rest of the contract there, which is enforceable. So what's your way around that? You put a provision in your contract that says if any provision in this contract is found to be unenforceable, it may be stricken and the rest is still enforceable. So that's just restating the blue pencil rule, saying that you anticipate the court may do that. When the rest of the agreement is enforceable is in 184, the restatement. Public policy and termination of at-will employees. Remember the quality control manager that reported the package mismarkings, that they weren't using sufficient quantity and quality of product? He reported that. Did he get a remedy for being fired? Yes, he did. You should not have to choose between your job or a crime. And then they talked about Restatement 90, promise reasonably inducing action or forbearance. They talked about discharge for cause. Can you fire somebody? Yeah, in a right to work state, which is a right to fire state, you can be fired for any reason except for an illegal reason. And if you put in your contract that it's only going to be for cause and here's your remedies, you have this review process like employee handbooks. If they say that that's your remedy, they've got to give you that remedy. Otherwise, they'll usually say we can terminate you for cause immediately without any other remedy. They're going to enforce that. Bala versus Gambro, Inc. This was when they fired their in-house counsel. You always have the right to fire your attorney at any time, and really for any reason. Family relations. Simeon versus Simeon. It's the prenuptial agreement where they decided that women no longer need protection by the court. They have arrived in society. They're able to protect themselves, therefore no protection. Uniform Premarital and Marital Agreements Act. That's a proposed uniform act that some states have adopted, giving when those prenuptial agreements or postnuptial agreements can be enforced or not. Remember, a reasonable disclosure is usually what's required. As long as they know about what they're getting into and what they're getting out of, it's what it requires for enforcement. Baby M, the surrogacy contract. Well, the mama, it was so unconscionable that they took the baby away from the mama and decided what to do for the baby in the baby's best interest without considering the baby's best interest. They held that that was not enforceable. And then Manuel Wackenheim versus France. I just put this one in there because it violated human dignity. Dwarf or little person tossing in French bars violates human dignity.
There was a case in the news about that again, like a week or two ago.
Oh, there's another event coming up.
It's coming up, that's what I'm saying.
And you'd have never paid attention to that on the news if you're not covered the text.
Right.
All right, remedies for breach, brand new chapter, chapter 7. Chapter 7 will be tested in its entirety. Campbell's suit. Campbell's was not entitled to enjoin the sale of the carrots by the farmers. The test in there is whether or not the inadequacy of the legal remedy is necessary to be determined by the facts of each particular case. In this case, they decided that Campbell's Soup can be compensated dollar amount for their losses rather than having to enjoin them from selling the carrots. So they denied them the injunction, but they granted them dollar amount legal relief. Deprivation of a loved one's companionship or the loss of a firm's goodwill, generally not compensable. So, can you sue somebody for taking away the love and affection of your spouse?
Yes.
Can you sue them? This is a trick question, folks. Can you sue them? You can sue for anything, right? Are you going to be able to recover from them for interfering with your spouse's relationships with you?
What all has been affected?
Is there a prenup? I never said y'all are married, right? Spouse, share, significant others? They say that they don't provide those remedies. Deprivation of a loved one's companionship. How do you calculate how much that's worth?
So that's in court.
All right, let's say companionship equals sex. How do you compensate somebody?
Go see what the going rate is.
I think there's a lot of people in Shelby County that just got arrested.
Yeah, you can ask the Birmingham Iron football.
The Birmingham Iron football team just lost one of their players to that arrest.
Yeah.
In Shelby County.
So I have a friend who was sued for defamation. She was and she had her homeowner's insurance, the liability policy under her homeowner's insurance actually compensated the other person.
Did they really?
What was that
For
again?
what?
Seriously?
I never thought about homeowners insurance.
Her husband, the girl who got sued, she was also married. Her husband was a lawyer and something has burned up with that. Anyway, he works for an insurance company, so he kind of knew some nuances. And yes, that homeowners and liability under homeowners paid that loss, deprivation of affection.
So here's the question: how'd they put a value on it?
I don't
They went
know
and checked the going rate.
Yeah, that may have been a nuisance case, cost of litigation. And loss of goodwill, generally you can't put dollar amounts on those. That's what you need to know out of your book, is you cannot put dollar amounts on them. Because putting a dollar amount on a sex act is what? Prostitution. What's that?
How is that a homeowner issue? How?
I don't know how that's homeowners.
I don't know.
I mean,
Trespass, maybe?
maybe it's a robbery, is what I was about to say. You stole my wallet.
Okay.
I need to look that up.
Is this the same as the loss of consortium?
Loss of consortium would be the affections. Yeah, it kind of is, but how do you put a dollar amount on it?
Well, I don't know, I was just worried if the terms were the same. I think that we hit on those terms and torts, and I was trying to connect.
It might be related. We'll just say the loss of companionship is hard to put a dollar amount on. So is the loss of a firm's goodwill.
Sometimes.
Can you figure out how much a firm has in goodwill?
I mean, sometimes that's in there.
Discharge.
Yeah, goodwill is how much more you pay for it rather than what's the dollar value of their assets on books, right?
Depending on the person.
You can get dollar value for that, but how do you determine what the loss of that value is? Based on competition moving in. I don't think you can. We had another case, it was Walgreens, I think, that addressed that. All right, Klein versus Pepsi. This was the corporate jet. They were trying to sue for specific performance to get the jet, saying that it was unique. But they found more than one for sale, so it was not unique. They did not have the right to enforce it. And then he got an updated model even cheaper. That just didn't make sense.
Did you read about 2 weeks ago on AL.com where the local Pepsi bottling company suing Pepsi for breach of contract?
No.
That was pretty interesting.
All right. The common law's preference for damages over specific performance is not found in civil law countries. civil law countries would just as soon give you an injunction than to give you dollars. In common law, the damages are dollars.
But didn't you say like Louisiana for civil law? Or would that be-
Yeah, Louisiana is based on civil law.
Right.
So they offer monthly, not dollars.
I guess you have the option of asking, and they're more liberal about their injunctions. Morris versus Sparrow, the ranch hand that trained the horse was entitled to the horse because the horse had skills after he got through training. Specific performance and investment. Remember the canned tomatoes case? Where they specifically geared up the facilities to handle tomatoes? They were entitled to the specific performance because of the expenditures that they made getting ready for that. Personal service contracts and the moral hazards. Talked about on 629 at note 3. If you have a personal contract with somebody to cut their grass, and you tell them that you're not going to cut their grass, can they sue you and get a court order ordering you to cut their grass?
Services are hard.
Can they?
Did they say they were going to cut it?
You cut it, you don't get paid, you can't sue them, you arbitration.
It's not unique.
So they can't force you because then the quality of the grass.
Give them money.
What if you don't want to cut their grass? Can they order you to do it anyway?
No.
What do you call that? Hey, don't laugh. It is called involuntary servitude, and that is slavery.
Can you clarify a little further what things are considered personal contracts? Because I'm not.
Are you going to do it yourself?
Like if I have a contract with her to cut my grass, in my mind, that's a business personal.
But if it's for her to cut your grass and not anybody else,
Like a personal service.
you want her to do it herself and not anybody else.
Can we have another example?
Okay, what if I hire somebody in this classroom to do a painting of me, and they don't want to do it?
Are you going to decide if you like the painting or decide it?
No, that's another case.
You hire somebody to sing, you hire me to dance. And I send Smith to dance instead of me.
You hire Shirley MacLaine to play in a movie. How about that? You hire Shirley MacLaine to play in a movie. And she decides she doesn't want to do it. Can she be made to do it?
So the issue is that you're trying to force that person to do something they don't want to do.
Right. So what are the damages for that? You sue them for the money rather than specific performance because it's involuntary servitude. Does that make sense? It's almost always going to be the money damages rather than the personal service. All right. And then they talk about moral hazards too. Negative injunctions. They talk about this in here because it's easier for them to order somebody not to do something than to order for them to do something. Why do you think that is?
It's too hard to go oversee.
Wait, now what?
Because the person who hired them.
It's easier to say don't than to wait until they do.
Yeah, what's the opposite of a negative injunction?
Positive injunction.
A positive injunction. What that is ordering somebody to do a specific act. Is it easier to order them to cease and desist or refrain than it is to order them to do something specific?
Yeah,
Yes. In most instances, courts are going to grant negative injunctions to keep you from doing something long before they order a positive injunction. The positive injunctions where I have seen it ordered is for a party to sign a deed, like in a divorce where they're dividing up property. I hereby order you to sign the deed relinquishing your rights over to your ex. But even then, if that order is not followed and the person refuses to do it, what's your remedy?
Well, they're in contempt of
They would be in contempt of court, so you put them in jail till they sign the deed, right?
Like, you can do that until they sign it?
And if you
Like,
get,
they
like,
just sit there?
if you get an official note to sign something, you're probably.
But more likely it's going to happen is the judge will just order the clerk to sign it in their stead. All right. Laclede Gas versus Amico. This is your residential propane provider that says they're going to provide propane until natural gas lines go in the neighborhood. That was a straightforward case. As soon as the natural gas lines went in, guess what? It's what they agreed to in their contract, right? So Restatement 361 and UCC 2-716 were referenced in that case. Now, Northern Delaware Industrial Development versus E.W. Bliss. It was a facility modernization contract where the plant owner sued for the contractor to hire more workers to get the work done sooner. Did the court make the contractor hire more workers? No. Walgreens versus Sierra Creek Property. Walgreens sought an injunction to keep the landlord from leasing out another pharmacy in the same area, or the same mall, to Farmore. Remember, Sierra Creek Property argued that Walgreens should be able to recover just the difference in the amount of prescription sales that they would have had, and that should be easily calculated. Walgreens insisted that you can't do it, and that they're entitled to the injunction. The court gave them the injunction. Specific performance with efficiency in the course theorem. So I put the course theorem actually in here for you, in case y'all missed it in the book. States that when transaction costs are absent or sufficiently small, and legal entitlements are well defined, parties will bargain to allocatively efficient outcome under the remedy. That is, let's do the plain English, the bargaining will result in the goods going to the party who values them the most, regardless of the remedy provided by the court. If you really want the goods, you're going to buy the goods, right? So what does that tell you about if I sue you for breach of contract for not selling me the goods, I can sue you and get the dollar value back, right? But then might I turn around and still buy those same goods from you? If I really want them, I'm going to. All right, measuring expectation. 347 of the restatement is the measure of damages in general. I put this next thing in all bold, which is your damages equation. There's one typo in there. It says damages minus, that should be an equal sign. Damages equals loss in value plus other loss minus the loss and cost avoided.
Can you give an example of that math?
If I am going to manufacture goods for you, and we've got an agreement that I will manufacture the goods for you, and then I will pay for shipping to deliver them to your business, and then you decide you don't want those, I've got the loss in value of the contract, right? Do I have any other losses? No. But do I save some costs by not delivering those parts to you? I save the shipping costs, don't I? So I would have the loss of the revenue from selling you the goods plus zero for other losses, but minus the costs I save by not having to pay for shipment. So my losses aren't the actual contract itself, it's whatever the contract is minus whatever I would save. Does that help?
Do that one more time. I need something.
If I'm going to sell you widgets, 10,000 widgets, and I've already got them manufactured and ready to ship. But you call me the day I finish manufacturing all 10,000 of them and say, I don't need them anymore. Can I sue you for breach of the sales contract to buy 10,000 widgets at $1 a piece? Now, if I was going to deliver those to you and it was going to take me $100 to deliver, put them on a truck and deliver them to you, then I've got 1,000 widgets at $1 a piece. That's $1,000. But $100 is how much it's going to cost me to ship them to you. Then I would get the $1,000 back for the loss of the sale price, minus the $100 that it would cost me to ship them to you, so I only get $900. You got that? Now, if I also had to pay for storage, so if I did the first 5,000 and then put those 5,000 in storage, while I was doing the other 5,000, then I would have the 10,000 manufacturing cost plus the cost of storing the 5,000 until I shipped them to you, minus the shipping cost of $100, and that would be my damages. Has everybody got that? I'd put a little star by that because there's probably going to be some question testing you on your ability to follow that equation. I don't know if it's going to be essay or multiple choice. And I'll tell you this on my multiple choices.
There's like 4 right answers.
Depending on which numbers you put in, there will be a right answer for that. So if you don't follow the equation correctly and you miss a step, then there's probably going to be a right answer for that. If you miss a different step, there'll be a right answer for it.
They're kind of like a stage.
I mean, it wouldn't be any fun if you didn't find a right answer, right?
Yes, actually.
You got to get the right answer.
Yes, ma'am.
When you say the loss of the value, is that like the expectation damage?
Yes.
And also when you say the amount it's cost and the loss of the shipping is one thing, but what's the other thing?
Well, how about insurance on the shipment? Insurance on the shipment? That'd be another cost of it. I mean, these days you want to insure shipments that you send with either UPS, FedEx, or
What about depreciation?
is what?
Depreciation, like if you had food, like
You remember last semester we talked about if the goods can be resold to somebody else and they're not specific to that particular business, then you get to deduct that. But if it's specific to that business, like the widgets, if I had your business name printed on the widgets, I couldn't sell those to anybody else. Yes?
And these are the damages, are these the damages that are awarded?
It's the damages that are calculated.
Or calculated? This is what you sue for?
This is how much you're supposed to sue for.
How much you're supposed to sue?
Whatever you can prove under this equation. Now, I'm going to dispute the fact that you don't have these costs, such as overhead, which is Vitex Manufacturing. The next case, they sued for not only the loss of the sale, but they wanted to recover their overhead costs as well, right? No, overhead. Like general and administrative expenses, secretaries, rent, utilities.
So in the calculated equation, they can be under the area of storage. Other losses.
Well, that's the way they argued it, yes. But the court went back in and said, wait a minute, those are all taken into consideration in the final sales price of your product, and therefore they're not really additional damages. And that's what they did in Vitex. The showerproof cloth manufacturer in the Virgin Islands, they tried to recover their overhead in addition to the loss of sale, and they said, wait a minute, your overhead's already included in there. All right, they have definition, repudiation by the assignor and novation with assignee. If you assign it, you are the assignor. If you are the recipient of the assignment, you are the assignee.
Can you repeat that one more time?
If you assign it, you're the assignor. assigner or the assignee if you are receiving the assignment. That's restatement 329. Then there's a discussion about marginal costs and marginal revenue. That's the cost to produce an additional amount. That's the margin. It's whatever is the additional amount. So, is your overhead included in your additional amount? No, you got the factory that you're paying utilities for anyway, right? So what's the marginal cost? It's usually the cost of materials and labor, right? This is the only extra amount you got to pay to get the extra products. What I'm trying to point out to you is in this portion of the book, they are nitpicking the crap out of that equation, aren't they? Okay. For the additional production of units, yes.
But the marginal revenue is the cost of producing.
No, the revenue is how much extra do you get for the sales versus how much extra do you spend for the sales. Let me ask you this hypothetical. How much does it cost for you to produce the first item? Yeah, a whole lot of money, right? In fact, there was a contract they put in that if they had to retool the factory, they wanted to make sure they got, well, that tomatoes for one, or that they were capable of bagging so much. All right, so how much does it cost you to staff up? Now, how much does it cost you to produce your 10,000th one? Yeah, I mean, it's probably nominal, right? The margin on there for the first one is very different from the margin on the 10,000 because it's only the additional cost is the marginal. What's the additional revenue on the margin? If I sell them all for $10 each, I get $10 for the first one, I get $10 for the 10,000. So the revenue is going to be per unit, but how much is the cost of production on each unit? It keeps getting smaller and smaller, right? All right, Laredo hides. H&H was to provide hides to Laredo to send off to Mexico to get tanned. H&H stopped sending them, so Laredo bought extras off the market. They held in that case that the buyer is entitled to recover whatever it is that they spent to get those replacement hides. The term that they use for that is cover, C-O-V-E-R, to cover the amounts that they were supposed to get under the contract. That term is defined in UCC 2-712, and then there's also 713 that's mentioned. Substitute transactions on 650 and the collateral source rule. This is where we talked about Les Miles. As a football coach, I think he's still on LSU's salary, isn't he?
No, I don't think so. Yeah, I don't think so. He just got hired by Kansas.
LSU
Yeah, but until he got hired by Kansas, he was still getting a paycheck from LSU.
Yeah. He's still getting one. It's just
Now-
less now.
He's still getting a paycheck from LSU, but it's less because he's getting income from Kansas, right? So that's the collateral source rule. LSU is able to deduct the amount that they have to pay less from the amount that he's receiving for comparable employment. So LSU's contracts for millions of dollars. They subtract what he's getting from Kansas from that, and they give him the difference. That's the effect of the collateral source rule on substitute transactions, getting employment elsewhere. All right, R.E. Davis Chemical versus Diasonics. The lost volume seller for canceled medical equipment for the clinic, where the clinic said, we want to buy this many units, and then they don't get their business license, and they say, nope, cancel that. Can R.E. Davis recover their lost profits, number one? Can they recover that? Yeah, they can recover lost profits, right? But what did they want to recover instead of just lost profits?
Their down payment.
They wanted the sales amount, not just the profit amount, right? So how do you recover the sales amount instead of just the profit?
Prove that you could have sold.
You argue volume sales. I would have sold these units anyway. So you get the entire purchase price rather than just whatever your profit is on. Losing contracts, UCC 2-718 and 709. That's where you underbid on a contract. And in order for you to finish up your contract, you're actually going to lose money. That's what a losing contract is. Now, do grocery stores do that? Do they offer items for sale cheaper than what it costs them? To get you into the store and do what? To buy more. So is it economically advantageous for you to have a losing deal if it gets them in and spends more money? Yeah.
I got my little hobby that I do. Like what's really common is they'll do like $50 or $75 online. It's free shipping. So like every time if I'm like at $45, I'll always look for a $10 item but shipping would be $5. So they do that like to make money. They do it all the time.
Buy something you don't want to get up to the minimum amount so you get something free. Yeah. People do that all the time. All right, U.S. versus Algernon Blair. They had a subcontractor come in and do the work, but then the contractor said they weren't going to pay him. So they said, fine, we'll just sue you. And they sued them for quantum merit, which is the value of what it is that they've supplied, rather than suing them on the contract. Because if they had sued on the contract, they'd have lost money. But under quantum merit, they were entitled to the value of what it is that they've provided. And the court allowed them to do that. They referenced 347 of the restatement in there. And then separately, 371. There's a discussion about having a contract price as a ceiling. This is the limit of how much you can get. But then that case, U.S. versus Algernon, just went beyond that, didn't it? So you're entitled to whatever it is that you've provided, even if you would not have recovered that much under a contract theory. Quasi-contract, which is quantum merit, you recover what you've provided. Getting into cost of completion and diminished value, Jacob and Young's. The homeowner sued for not paying for the plumbing because it was not from the certain manufacturer, Reading Pipe, up in Pennsylvania. They sued the builder because it wasn't Reading Plumbing. But the court said the plumbing was good enough, so they ordered them to have to pay for it. Plant versus Jacobs. This is where the living room wall was built 1 foot off where it was supposed to be. They tried to sue the builder and not have to pay for the rest of it, or the builder sued. They tried to get out of paying for the rest of the contract price because it wasn't built according to specifications. The wall was in a different place. The court said that would be unreasonable economic waste to make them tear down the wall and move it and build it again. And they weren't going to make them do it, that it was substantial performance. Groves versus John Wonder. That's the excavation of the sand and gravel. They required them to go back and smooth over the land, or grade it, G-R-A-D-E, and then cover it with dirt, right? But the company didn't do that. They just abandoned it the way it was after they took the sand and gravel they wanted. The court said substantial performance is not available to a party that willfully and fraudulently varied from the terms of the contract. In case y'all didn't notice, that's called clean hands. We've covered that before. This is the clean hands doctrine all over again. You don't have clean hands because you didn't do what you were supposed to under the contract. Therefore, you cannot claim the equitable remedy of substantial performance. PV House versus Garland Coal and Mining. This was the strip mining. And here they wanted to sue to actually finish covering up where they strip mined. But then the coal and mining company came in and said, nope, all you're entitled to is the difference in value of the property. And the court actually went for that, the difference in value. Limitations of damages, avoidability. If you can avoid unnecessary expenses, you have a duty to mitigate. Yes?
Is that like a material group? Is that what's the groves and...
It looks to me the difference between Groves and Garland is that Groves argued that it was willful and fraudulent, and PV House did not argue that it was willful and fraudulent.
So plant maybe the Jacobs are material breaches?
I didn't hear you.
Plants and Jacobs would be like material breaches, like it was not a material breach, so they, is that the reason?
Well, I would call it a material breach if you don't leave the land in the condition that it's supposed to be when you said you'd do it.
Well, more about the wall, the homeowner wall.
Okay. Is that material breach?
It's not.
I don't think they argued that. I just think they argued that it would be an unreasonable economic waste to have them to tear down the wall and to rebuild it in the proper location. Is it substantial performance? Yes, they built a wall. Did they get it almost in the right place? Yeah, it was only a foot off. Did that make a difference in the size of the room? Yeah, by 1 foot. And if it's 10 feet long, it's 10 square feet difference. Is that a whole lot in an 18,000 square foot home? Now, would it make a difference? I'll ask you this hypothetical. If you've got a walkway up to your front door, and we'll say that the walkway you designed it to be 3 feet wide, and they missed it by a foot and made it only 2 feet wide, would that be a material breach? Yeah, it's not handicap accessible, right? And how wide are most doors? About 3 feet, right? So what are they going to have to do to put a door up? They're going to have to cut a foot off the door, and that gives you like this much space to get through the front door. Now, would that be unreasonable economic waste to have them tear that down and move it at that point?
No.
I don't think it'd be unreasonable, do you? So, I mean, it depends on each case. All right, avoidability. Rockingham County versus Luton Bridge Company. The county called up and said, whoa, stop working. And they went ahead and built it anyway. And then they sued for the entire price of the bridge. And the court came back in and said, you know, you've got a duty to mitigate your losses. If you'd only spent $10 up to the point where they said stop working, the next million's on you. You should have never spent the million because you knew the county wasn't going to pay for it. UCC 2-704 was mentioned, as well as 708 and 712, and 06 and 13 and 08, 23 and 24. They just rambled right through those numbers. Tungish v. Thomas. This was the fun case where the co-op charged 55 cents per hundredweight as a handling charge for sunflower seeds. And they had large sunflower seeds and small sunflower seeds, and the price was varying according to those. But they would buy up all the seeds and then turn around and sell them to vendors that needed them. And so when they sued for breach of contract for not selling them the seeds, the growers came in and said, oh, the only thing they're entitled to is what they get out of the contract, which is 55 cents per hundredweight. And the court said, no, what they get in their contract is the difference in value of what you provided versus what you said you'd provide. Now, looking at it logically, kind of extrapolating from this case, why do you think the court gives them the full amount instead of just their handling charge? Huh? Well, there's two contracts, right? One between the grower and the co-op, and one between the co-op and the buyer. The only contract in front of them was the grower and the co-op, right? Now, what if the buyer sued the co-op? Then as a result of the two lawsuits, the only thing the co-op would be left with is the 55 cents per hundredweight. But the buyer is entitled to their lost money from the grower as well, right? But it passes through a middleman. So they're entitled to the full contract cost of the seeds that they didn't get, maybe in anticipation that the buyer may sue them also, and they're entitled to get their full recovery, which would leave them with 55 cents per hundredweight. You see why you have to fully compensate the contract? Because they might be sued. Of course, they might not. But you can't leave them out in the hole like that. Yes, ma'am. Did you raise your hand? Parker versus 20th Century Fox. Shirley MacLaine. And you offer her a part in a different film, and she doesn't take it. Well, by golly, we offered her comparable employment. She should have mitigated her damages, right?
Not so. There's a difference.
Yeah, the court made a big difference in finding between the movie roles, right? One was singing and dancing, and the other one was
Directing. She was in charge of the script or something.
well, that was the first one. Singing, dancing, and control over the script versus you just sit there. Well, I mean, you act, but there's no singing and dancing and no control over the script. So was it comparable employment? The court held that it was not. She had no duty to accept something that was not comparable. All right, foreseeability. Hadley versus Baxendale. I went ahead and not just italicized that, which you usually do for cases, but I bolded it too, to bring your attention to the fact that this is one of those big cases that you need to get a full understanding of by the time you get out of contracts. And that is, for damages to be recoverable, they have to be foreseeable. In Hadley versus Baxendale, they took some sort of shaft for a piece of machine, and they told the shipper that they needed this back ASAP. In fact, they even told the clerk at the counter that we've got people sitting here waiting to work until the replacement comes in. The clerk did not note that. All they did is said, if you can have it here by noon, we'll get it out same day. They got it there by noon. They did not get it out the same day. It was several days later. So they sued for, I guess, the lost wages and that they had to pay to the workers while they were sitting there not doing any work. And the court held that that wasn't foreseeable for a shipping contract because there was no note made of it that said that these damages are going to be incurred if you don't get it done on time. So what's the key in making sure that you're going to be able to recover damages if you're drafting a contract? Document the crap out of it. If you have damages that you expect are going to be incurred, make sure you tell the other side that these are the damages you expect if they don't get their work done on time. And then the other thing we learned a couple pages later is put time is of the essence in your contract so that they know that you are sitting there and time is costing you money. All right, so they mentioned restatement 351 and UCC 2-715. I think on 691, that case is actually from out of a note. I forgot to put the note number on it, but it's British Columbia Sawmill versus Nettleship. The guy stopped by to get a new horseshoe put on his horse because he was on his way to go get married to some princess, I think. Wasn't it a princess?
She was rich. She was an heiress. Yeah.
An heiress. And because they didn't put the horseshoe on good, the horse became lame and he didn't make it to the wedding, so she married somebody else.
She looks bad.
It really makes you question the whole relationship.
I was waiting for somebody to say that. How bad did the heiress really love him?
Maybe it was an arranged marriage. It was a timeline. She had him.
Maybe it was an arranged marriage. All right, so were his expenses, or was his expectation of becoming a kept man foreseeable by the blacksmith that put on the horseshoe? No, they said it wasn't. Delkey Carrier Spa versus Rotorex. They shipped out defective air conditioner compressors. Was it foreseeable that they would shut down the air conditioner production line if they didn't ship air conditioner compressors that actually worked? In that case, they held that it is foreseeable because the air conditioner compressors were being shipped to an air conditioner manufacturer whose facility was waiting for just-in-time inventory. Kenford versus Erie County. I think this is New Jersey, isn't it? Erie County, New Jersey, where the New York Giants play football. Where they were supposed to build a stadium for them to play football. And when he found out where the stadium was going to be built, he bought up all the property around it. And when they decided not to build the stadium, he sued them because he thought all that property he bought up should have appreciated in value if they'd actually built the stadium there. Yes, it is. But they say it in terms of it was not foreseeable that he'd go out and buy up all that property and expect the increase in property values. UCC 2-715. And then we get to sentimental value. Sentimental and fanciful values are not allowed. Sentimental and fanciful. All right, emotional distress. What you need to know about emotional distress is it's in a state of flux. Some places allow it and some places don't. Alabama does on the sales of homes. There was a case in your book about emotional distress from the sale of a personal residence. Then they get into having to prove it with certainty. Farah versus Village Plaza was breach of anticipated profits. That was a new business moving into a place. They did not have a track record on what their profits have been. So they said, this is how much we expect our profits would have been. Now the fun part, liquidated damages versus penalties. Liquidated damages good, penalties bad, right? Dave Gustafson versus State, the road resurfacing contract. They had a provision for liquidated damages. It was so much dollars per day for the 87 days he was late. And they assessed him that. He said that that was a penalty, and they said, no, this liquidated damages because we don't know the cost to our community for having this road closed. By the way, somebody was talking to somebody about Niagara Falls the other day. They said, yeah, if you walk into Niagara Falls from the U.S., you can walk back. But if you drive over the bridge, you can't just drive back. You have to drive 20 miles around to get back into the United States. Well, that's an example of a road closure, right? Now, how much would it cost everybody who commutes there to pay to go the extra 20 miles to get back? That's kind of a variation on this fact pattern, but you see the example. If it's a road closed, how much does it cost? We don't know. What's everybody's gas mileage? How many people drive the road every day? Is there a way to predict all of that? And so does a municipality or a state have an interest in protecting people from having those additional expenses? Yes. So if they create a liquidated damages amount based on a fair and reasonable calculation of what they expect the inconvenience is going to be, then it's going to be upheld. Lake River Court versus Carborundum Company. This is where they bought the sand and gravel bagger machine, right? And they wanted to have a guaranteed minimum amount of sand and gravel that they would bag. And when they no longer needed sand and gravel and told them halfway through the contract that they didn't need any more, they sued to recover for the minimum quantity specified on their contract that says this is the minimum that we'll buy. We could buy more, but this is the guaranteed amount that we're going to buy from you. The court came back and said that was punitive, so it was a penalty rather than liquidated, because it had nothing to do with the output that they expected or the amount to be supplied under the contract. It was a penalty for not keeping the contract. Wasserman's versus Township of Middletown. This is a lease of town property. City or town owned it, and they provided in there that if you breach the lease, then they'll pay so much money plus 25% of whatever your average gross annual receipts are. And the city tried to get out of paying the average annual gross receipts by saying that that was a penalty. But because of the breach and the way that they calculated that it was a reasonable amount, they said that it was actually liquidated damages. Page 720 is a good discussion between the difference on liquidated damages and a penalty. Put a star by that because it defines both of those very well in a paragraph that's indented. Liquidated damages are this. This is what a penalty is. Page 720 in your book. Hold on, I'm telling you what the paragraph says. It's the first indented paragraph on the top of 720. It says liquidated damages is the sum a party to a contract agrees to pay if he breaks some promise. And in that same paragraph, a penalty is the sum a party agrees to pay in the event of a breach, but which is fixed, not as a pre-estimate of probable actual damages, but as a punishment. So that's, make sure you study that. Okay, now a question. Yes. There's an or in there. They say that as long as they reasonably calculated at the time of the contract or at the time of the breach, then they will be upheld. Right, but as long as they're reasonable estimate of the time of the damages that you expect at the time you make the contract or the damages that you actually incur at the time of the breach, then they'll be upheld. Yes. And as long as it's reasonable under either of those circumstances, then the court should uphold it.
So what makes a penalty and the liquidated damages different as far as that? Reasonable or unreasonable?
All right. The example that we talked about in class is your cell phone contract. Remember that? How many of you've got AT&T or Verizon for your cell phone carrier? Do you remember back a few years ago where it said, if you terminate your contract, there's a $200 cancellation fee? Remember that?
Other companies would buy you out.
Is that your question? Yeah, your question. Remember the $200 to terminate the contract? Well, if you terminated it the day after you signed the contract, it's $200, right? If you terminate it the day before the contract expires because you want to buy a new phone, how much are AT&T's damages on the last day of the contract versus how much are they on the first day of the contract? Still $200. Is that related in any way to what their actual cost is under the contract? And there was an actual case out of California where they did that. It's in your book. And they said these fixed price termination clauses are not liquidated damages, they're a penalty. And so what AT&T and I think Verizon has now done is it says, for every month you terminate early, it's going to be this much. Now, is that calculated reasonably to the amount that they would suffer based on an amount of time that you've actually kept the contract? It's closer. You might still be able to argue it's punitive or a penalty, but they can at least come back and say, well, if we spent $200 to get you a phone and you've paid us back for 11 months, then you only really have to pay us back 1/12 of what we forwarded you as buying back your phone on this contract. So does that help with the penalty versus liquidated? The $20 a month is liquidated. The $200 was a penalty because it made a difference on the first or the last day. And that's really what they used on that gravel bagging case, was that they were entitled to the same amount of damages on the first day of the contract and on the last. It was whatever their minimum buy was on the first day or on the last. It didn't matter how much they bought. It was still the same amount. That's why they found it was penalty. All right. Chapter 8, page 725. UCC 2-609 says that you have a right to adequate assurance of performance. The term you need to know out of that is anticipatory repudiation. If you expect the party's not going to perform, good faith requires that they give you an adequate assurance that they are actually going to do what they promised to.
Is that only a virgin or with regards to goods since it's under the UCC that we're talking about?
Well, it's only to goods under the UCC under 2-609, but under even common law contract law, you are still entitled to an adequate assurance that the person is going to do what they promised they would do. So, section number 1, conditions. If you get anything out of this section, it is that conditions versus duties, that whenever you go to court, you want the court to uphold the contract, then the courts are going to interpret something as a duty rather than as a condition. Because if it's a condition precedent, and that condition fails, then you have no additional duties under the contract. However, if it's just a duty, and they fail to perform that, that's a breach that you can recover for breach of contract. Look at the earnest money example. Oh, the condition is defined at Restatement 224. Ludinger versus Rosen, the earnest money, they put down 10% on a house and said, this offer is contingent upon us getting financing at 8.5% for 20 years. And the only finance company out there that would do anything close to that said, we'll give you 8 3/4 for 25 years. Well, did the condition of getting 8.5 for 20 years, was that ever satisfied? And so was there an agreement to buy the house?
No.
No, there's not. So the condition keeps there from being in an agreement. But if you say these are your duties under the contract and you don't do one of the duties, you still have a contract. But you have a breach for it rather than a failed condition.
So is that why they tried to bring up the fact that they didn't feel they met their duty by going to enough lenders to look and see if they could get a better rate? And then they said our attorney already knew this, but that was why they approached it from the duties perspective?
From the condition perspective, the fact that they made an offer to them to finance the difference was a separate offer. It's not breaching the same agreement if it's a new offer. Everybody see the difference on that? An offer to provide the difference in financing is another offer for which there has to be an acceptance. There was not, so there was not an agreement. And did they breach the first contract when they didn't get the financing that they needed? They didn't meet the condition. And then they argued lack of good faith, but then the court came back and said the law doesn't require you to do something which is futile. And if they knew, because of their knowledge of the market, that this is the only lender that would do that, then it would have been futile to go to anybody else. Now, is that the same problem we have in Birmingham? No, you got lots of lenders out there. So you can shop around to a whole bunch of them. How many vendors does it require before it's good faith?
It didn't say.
Huh?
It didn't say. I mean, it could be.
Didn't say, did it?
I mean, what I think is good faith and what you think is good faith when I'm buying a house from you is a completely different animal. Unless it states in the contract, you must go to extra for lending.
But it comes down to what's reasonable.
What do you have to sign?
Right, but what's reasonable?
The courts say that that's the reasonable expectations of the parties. All right, so International Rotterdam versus Riverbrand Rice. This is where the rice was promised to be delivered to Louisiana and Texas. You have to tell me where to ship it to in Texas and where to ship it to in Louisiana, and I will ship it there. But we have to ship it out no later than December. And you got to give me a 2-week advance notice of where you want it shipped. So they came December 17th, and there wasn't an order telling them where to deliver for it to be shipped. Their attorney said, well, if you don't give us notice 2 weeks in advance, and we can't end up shipping it within the month of December, then you've breached, and you're not entitled to recover for your damages. The court went along with that. It's easy to figure out. 31 days in December minus 14 days advance notice means you have to get it by the 17th, and if you don't, then you have not been given adequate time to perform your duties under the contract. Separate contracts. They talked about the possibility that this one contract could be divided up into two. One contract for the delivery to Louisiana and another contract with the delivery to Houston. But it was really inseparable. And they talked about if it had been two separate contracts, then they could have enforced the one to Louisiana where they did actually do everything they were supposed to, even though they'd breached the one in Houston. All right, so problems with interpretation. Is it a condition, a duty, or both? Peacock Construction, right after Restatement 227. Peacock Construction, they had a contractor who subcontracted the air conditioning work, and the subcontractor got done and said, okay, I'm ready to be paid. And the contractor came in and said, well, you don't get paid until we get paid. And the court went into all this explanation about small businesses and the fact that contractors or big businesses are more economically able to survive payment or non-payment by the owner until all the work's done. The contractor said that their prepayment by the owner was a condition to them paying the subcontractor. And they said, no, it's not. You have a duty to pay him when it's done. And it doesn't matter if you get paid first or not, you still have a duty to pay him for it. Now, does that make sense?
Yeah, actually.
From a common sense point of view, does that make sense? All right, how many contracts are there?
There's one between the buyer and the contractor, then there's the contractor and the sub.
So there's at least two contracts, the buyer and the contractor and the subcontractor.
Goes back to the other one we were talking about,
With the rights, it was inseparable.
So if they contracted.
They said had it been two separate contracts, maybe, but this contract was inseparable for the rights. So what?
I said, well, if the contractor made a contract with a subcontractor, then the buyer's not involved in that. So
That's right.
The payment doesn't matter, right?
Well, can the subcontractor sue the buyer
No.
for breach of contract?
No.
He doesn't have a contract with him, right?
What's the risk, I guess? The risk of non-payment between the buyer, from the buyer to general contractor.
But that's what contracting is all about, is assignment of risk, right? They said the contractor was in a better position to assume the risk than a small business subcontractor. Yes, ma'am.
Is this duty some kind of public policy or legislative thing?
It sure looked like the court adopted a policy that says we're going to take care of small business. Doesn't it? Pay if paid on 737. I will pay you if I get paid.
Attorneys do that, don't they, when they take on suits?
Yeah, but that's not two contracts, is it?
No.
It's the one contract. They can do that. All right, Gibson versus Cranage. Pay me if you like the painting. Is that a duty or is that a condition?
That's condition.
Condition because if they don't like it, they have no duty, right? All right, third party satisfaction. They talked about doing the work to the satisfaction of an architect. Is that okay to do? In fact, that was McKenna versus Vernon, wasn't it? Down toward the bottom. All right, so your mitigation doctrines: prevention, waiver, estoppel, election, interpretation, and avoidance of forfeiture. That's the rest of what we've covered in Section C for this semester. So prevention. You cannot cause your own duty to keep from occurring. You cannot make a condition fail to keep your obligations from arising. Then they talked about waiver, estoppel, and election. All right, y'all know what waiver is, right? Where your conduct in the course of proceedings keeps you from being able to assert a different position. That's waiver. Estoppel. You know what estoppel is. It's where you can't assert one position one time and then a different position another. Does it sound an awful lot like waiver? Sort of. Waiver is typically behaviors. Estoppel can be not just behavior, but also what you say. If you say one thing, you can't go back and change your mind on another. Election. How many of y'all have actually had homes built? A contractor came in and built your home for you.
Biggest
Now,
mistake of my life.
did they also paint the walls that they built for you?
I mean, they did it
All right, did you have to pick your paint color?
Yes.
And once you picked your paint color, could you change your mind after they painted it?
With a change order and a fee.
That's called an election. When you elect one thing, you've eliminated the possibility of selecting something else. That's election. I will paint your rooms for you between one of these colors. You pick one, and you're stuck with it. All right, so under waiver estoppel in election, they talk about restatement 84 and UCC 2-209. The election is a choice binding on a party is on 744. That's you pick your paint colors. Anti-waiver clauses. The example I gave you in class is in visitation with children. That in your divorce or in your child custody paperwork, you say that the non-custodial parent has the right to visit with the child on these occasions. However, the failure to exercise one of those visits is not a waiver as to any future visits. By the way, the courts are going to interpret that anyway. But in contracts, if you're going to draft up a contract that says, if I fail to send you out an invoice this month, it doesn't mean I'm waiving payment, that would be an anti-waiver as well. McKenna versus Vernon. This is the movie Pictures Theater, or a motion picture theater. It's a movie theater, even though they want to call it by strange names. They agreed to build one, and that the builder would be paid in installments according to the percentage of work done, each step being approved by the architect. So they finished step 1. They got payment. Nobody asked for the architect letter. They finished phase 2. They got payment. Nobody asked for the architect letter. Phase 3, they got paid without asking for an architect letter. When it came down to the last one, they said, whoa, we don't want to pay you until our architect approves it. And they stood up and said, really? All these times you've never waited for one, why now? It's a ruse, right? And that's what the court found, is that they had waived their right to that. The benefits of lenience, just because you don't collect what's due the month it's due, or even the next month or the month after, doesn't mean that the client still doesn't owe the money. No matter how long it takes you to actually come forward and finally say, look, this is long enough. All right, interpretation and avoidance of a forfeiture. Hicks versus Bush. This was that corporate merger. Huh? Yeah, they said that it was contingent upon financing, but the opinion actually started off by saying this is a fully incorporated agreement. A fully incorporated agreement. And then they started talking about parole evidence, about how they did not include certain provisions in their contract, one of which was a condition that the merger was only going to happen if they got the financing necessary for the business to get off the ground. One person transferred all their stock into the business and was insisting that the other one do the same after they failed to get the financing. And the court held that because it was not inconsistent with any written term in the fully incorporated agreement, that they could introduce parole evidence that there was a condition precedent that they had to get the financing before the joint venture would become an obligation. And they let him out of it. UCC 2-202, they reference right after that. And then merger clauses and conditions. Make sure that you make it a condition and not a duty if you're going to draft up something like that. Best advice is stay away from mergers and acquisitions. But if you really insist on doing it, protect your client to keep them out of something by making it a condition precedent rather than just a duty under the contract. Now, the exam. I anticipate 30 multiple choice questions and 1 essay. Same way as before, 54 minutes, I think, to do the multiple choice, 30 minutes to do your essay. If y'all have not figured it out by now, I like to use old bar questions for my essays, or at least a variant of them. So you can expect a bar question or a variant of a bar question covering one or more of the subjects that we're testing in.
30 minutes for the essay.
Yeah, one or more.
30 minutes for the essay.
30 minutes for the essay. And then the multiple choice questions, just about those materials that we've covered today. All right, if there are no questions, if you came in after I called roll, please come see me so I can get you on the roll. And good luck studying this week, and hope everybody gets an A next week.